Hi, my name is Stacy Maurier, and I'm the founding lawyer of Estate Connection Law Office in St. Albert, Alberta. Today, I'm going to talk a little bit about a very scary but simple process that sometimes causes our clients concern. It's resealing a grant of probate. What does that mean, and when is it used? So, resealing a grant is essentially the same as probating a will, except for a little difference in the paperwork. But what it does is it allows a grant from another jurisdiction, if it's outside the province of Alberta, to be sealed and placed in the courts here so that people can rely on the documentation. Now, for some of you that have property in BC, you might have heard that you might need to do that because you have a house in BC as well as real estate in Alberta. And in that case, if something should happen to you, we need the courts to be able to recognize your documentation in both provinces. So the grant would be applied for in Alberta, and then your executor would reseal it in BC. It is a time-consuming process and does cost a little bit of money, especially when we're looking at provinces outside Alberta, because we're fortunate and have such low probate fees. So what resealing does is it allows a different province, a different state, or a different country to recognize the documentation that's been done in Alberta. The documentation that is done to probate and provide confirmation that your executor can actually handle your estate. Now, in our office, we've probated wills from all over Germany, Czechoslovakia, Australia, Hawaii. And in those situations, for whatever reason, people had purchased property in Alberta. Sometimes they inherited it or had mineral rights. So their estates were dealt with in their home jurisdiction. The documentation was then sent to Alberta, and we did the resealing process so that we'd get that fancy stamp from the courts, and then the executor could deal with whatever assets they had in Alberta. So one way you can avoid resealing is to think about creating a will that is just for that jurisdiction. So for instance, for someone who owns a house in BC and a house in Alberta, they might want to have an Alberta will, which deals with all their Alberta assets, and then a BC will, which would deal with any property that's located in BC. Now this does two things. If you have just one will, first we go through Alberta and then we refile and bring it into BC. So we're looking at double the time period. However, if you have two wills that deal separately with different property, they can both go through the system simultaneously and are actually originals where you're applying for the grant. So we're not resealing, we're actually in a new application. There's pros and cons to this, and it really depends on the jurisdiction. If you own assets or property outside Alberta, talk to an estate lawyer. Give our office a call and we can give you some advice on what you should be doing with those assets. Our number, 780-458-8228. Contact Estate Connection today. Thank you.